The right to vote in Nigeria is viewed by some as a mere civil responsibility, a right dependent on law, while others see it as a fundamental political right. Yet to another group, it's just a franchise or a privilege. A scholar once described the right to vote as a fundamental political right as it produces the most direct verdicts by the citizens on the performance of those who govern them. Welcome to this week's edition of Law Weekly. My name is Victoria Ido. On the program today, Law Weekly would explore the rights of a voter, and we will try to understand what we need to do if the right is not enforced. But first, let's take some headlines.
A federal high court in Lagos on Monday fixed March 16, 2015, for judgment in a suit filed by rights activist and lawyer Ebunolu Adeburua, seeking to stop restriction of human movement on the last Saturday of every month for the purpose of observing environmental sanitation in Lagos State. Adeburua had filed the suit to contend that there was no law in force in Lagos State presently restricting movement of persons for the purpose of observing environmental sanitation. While arguing the matter, Adeburua submitted that Section 39 of the Environmental Sanitation Law 2000 of the Lagos State Government, which the respondent claimed to empower the Commissioner for the Environment to make regulations, could not be the basis of restricting human movement on Saturdays, as no regulation in force had indeed been made for that purpose. In response, Chief State Counsel to the Lagos State Ministry of Justice, Jonathan Ogunsanya, argued that Section 41 of the 1999 Constitution permits government to make laws that may derogate from the right to freedom of movement, and that the Environmental Sanitation Law of Lagos State 2000 was an example of such derogation. In a bid to further prevent Prophet Temitope Joshua from appearing before the coroner, the registered trustees of the Synagogue Church of All Nations, Cohen, had filed a notice of appeal at the Lagos Division of the Court of Appeal against the judgment of Justice Latifa Okunu of a Lagos High Court sitting in Ikeja. The counsel to Cohen, Sheun Abimbola, made this known while reacting to a request that the council should pick a date that the prophet would appear, put by the Chief Magistrate, Oyetade Komolafe. Justice Okunu had thrown out an application instituted by Cohen alongside its founder, which had asked the court to stop the ongoing coroner's inquest into the collapsed guest house belonging to the church. The judge's reason for the dismissal was that the said application was premature and lacks merit. Justice Okunu declared that although the coroner's court cannot be sued, Chief Magistrate Komolafe himself could be sued in his capacity as a coroner. The judge stated further that the court needs to resolve the issues as to whether the coroner had acted contrary to the rules of natural justice by not granting the application a fair hearing, and whether he has exceeded the scope of a coroner's inquest. Justice Okunu explained that Section 26 and 27 of the Coroner's System Law of Lagos State 2007 empowered the coroner to summon any witness to assist him in his fact-finding mission, adding that there was nothing unusual in the summons extended to Prophet Joshua. A court of appeal sitting in Abuja has stayed the execution of the death sentences passed on 2 of the 12 Nigerian soldiers court-martialed by the army authorities last September. The soldiers were tried under the General Court-Martial, which sat at the Army Headquarters Garrison Mogadishu Cantonment in Abuja on allegations of offences of conspiracy to commit mutiny and mutiny under the Armed Forces Act 2004. 3 of the convicted soldiers, Corporal Stephen Clement, Corporal Igomo Emmanuel, and Private Andrew Mbede, however, approached the appellate court through their lawyer, Chief Godwin Obla, a senior advocate of Nigeria, to challenge the decision of the court-martial, which convicted and sentenced them to life imprisonment and death. The convicted soldiers raised 11 grounds of appeal, each in their separate appeals challenging the very many fundamental irregularities and improprieties characterizing the entire trial at the General Court-Martial, and have asked the court to stay the execution of their sentences pending the hearing and determination of their appeals. In his ruling, the lead judge, Justice Abubakar Abdul Qadir, restrained the Nigerian army or its agents from carrying out the execution of life imprisonment and death sentence imposed by the General Court-Martial and ordered that the convicted soldiers be granted access to their lawyers. 21 army officers accused of negligence and complicity during the raid of the 21 Artillery Brigade, Bama, Borno State, on September 2, 2014 by Boko Haram militants have pleaded not guilty to the charges. Meanwhile, the trial of a Brigadier General, who was also arraigned with the 21, has been adjourned indefinitely. That of the other accused persons has been adjourned till Wednesday and Thursday by the General Court-Martial, presided over by Major General S.D. Aliyu. The officers are accused, among other offences, of cowardly behaviour, which is said to attract the death penalty. At the commencement of the trial, journalists were refused access to the General Court-Martial by military authorities, saying the case was not for coverage. Several army officers have been court-martialed and sentenced since the beginning of the onslaught against the insurgents in the northeast, bordering on negligence of professional duties. The Young Democratic Party may have won its case against the Independent National Electoral Commission on the issue of its registration, but it appears it also has a case to answer. A federal high court in Abuja has threatened to charge the YDP with contempt of court for misinforming the public on its ruling in the case against the electoral umpire. The YDP had asked INEC to reprint ballot papers to include it in the elections, but the court insists that it only ruled on the registration of the YDP as a political party and to be issued with a certificate. A People's Democratic Party PDP chief, Waliu Taiwo, has filed a suit at the Federal High Court in Lagos seeking to stop the use of the electronic card readers during the general elections. The plaintiff is seeking an order restraining the Independent National Electoral Commission INEC from using the card readers during the polls. Taiwo, who is a PDP candidate for the Ogun West Senatorial District, claims that INEC's guidelines, which stipulates the use of card readers, is unconstitutional and should be nullified. He particularly faulted Section 12C of the guidelines, which states that in the event that the PVC fails to be read by the card reader, the APO, that's the Assistant Presiding Officer, shall file a report of the incident, inform the voter of the problem, and that he or she cannot be accredited, and politely request the voter to leave the polling zone. The plaintiff said this is the first time anywhere in the world where a device such as the card reader, as proposed by INEC, would be used to the effect that it supersedes the content of the register of voters properly compiled by the electoral body. He joined the Attorney General of the Federation, Mohammed Bello Adoke San, as the second defendant.